American Government, 4th edition, an OpenStax textbook. This audiobook was produced by Open Audio and is narrated by Brian Barrick and Sarah Aria. Read along with the full text at www.openstax.org. You can listen to this free audiobook anywhere you listen to podcasts, including Spotify, YouTube, Apple Podcasts, or on our website at www.openaudio.us. Chapter 4: Civil Liberties.
Introduction.
Black Lives Matter demonstrations across the nation provided an example of the freedom of assembly protected by the Bill of Rights. This right may now be in jeopardy as bills in several state legislatures threaten peaceful gatherings and even shield citizens who attack such protesters. Fights like this, in the streets, courts, legislatures, and public opinion, are hardly unique in U.S. history. In fact, they are the main driver of political change. 2025 protests against President Trump's policies, and especially those targeting Tesla, the company of key Trump advisor Elon Musk, were met with threats of severe punishment for vandalism or destruction of Tesla property or vehicles. The framers of the Constitution wanted a government that would not repeat the abuses of individual liberties and rights that caused them to declare independence from Britain. However, laws and other parchment barriers or written documents alone have not protected freedoms over the years. Instead, citizens have learned the truth of the old saying, often attributed to Thomas Jefferson, but actually said by Irish politician John Philpot Curran, "Eternal vigilance is the price of liberty." The actions of ordinary citizens, lawyers, and politicians have been at the core of a vigilant effort to protect constitutional liberties. But what are those freedoms, and how should we balance them against the interests of society and other individuals? These are the key questions we will tackle in this chapter.
What are civil liberties? Learning objectives. By the end of this section, you will be able to define civil liberties and civil rights, describe the origin of civil liberties in the U.S. context, identify the key positions on civil liberties taken at the Constitutional Convention, explain the Civil War origin of concern that the states should respect civil liberties.
The U.S. Constitution, in particular the first 10 amendments that form the Bill of Rights, protects the freedoms and rights of individuals. It does not limit this protection just to citizens or adults. Instead, in most cases, the Constitution simply refers to persons, which over time has grown to mean that even children, visitors from other countries, and immigrants, permanent or temporary, legal or undocumented, enjoy the same freedoms when they are in the United States or its territories as adult citizens do. So, whether you're a Japanese tourist visiting Disney World or someone who has stayed beyond the limit of days allowed on your visa, you do not sacrifice your liberties. In everyday conversation, we tend to treat freedoms, liberties, and rights as interchangeable, similar to how separation of powers and checks and balances are often used synonymously, when in fact these are distinct concepts. Defining civil liberties. To be more precise in their language, political scientists and legal experts make a distinction between civil liberties and civil rights, even though the Constitution has been interpreted to protect both. We typically envision civil liberties as limitations on government power, intended to protect freedoms upon which governments may not legally intrude. For example, the First Amendment denies the government the power to prohibit the free exercise of religion. This means that neither states nor the national government can forbid people to follow a religion of their choice, even if politicians and judges think the religion is misguided, blasphemous, or otherwise inappropriate. Unlike most of the rest of the world at the time, U.S. citizens could even create their own faiths and recruit followers to them, subject to the U.S. Supreme Court deeming it a religion, even if both society and government disapprove of its tenets. That said, the way you practice your religion, like any other practice, may be regulated if it impinges on the rights of others. To return to the previous example, religious communities may believe their faith will protect them and loved ones from disease, but they may not have the right to both not vaccinate their children and have those children publicly educated, where they would pose a risk to others. The Eighth Amendment says the government cannot impose cruel and unusual punishments on individuals for their criminal acts. Although the definitions of cruel and unusual have expanded over the years, the courts have generally and consistently interpreted this provision as making it unconstitutional for government officials to torture suspects. As we will see later in this chapter, courts are currently debating the degree to which extended solitary confinement and certain forms of capital punishment might count as cruel and unusual. Civil rights, on the other hand, are guarantees that government officials will treat people equally, and that decisions will be made on the basis of merit rather than race, gender, or other personal characteristics. Because of the Constitution's civil rights guarantee, it is unlawful for any publicly funded entity, such as a school or state university, or even a landlord or potential landlord, to treat people differently based on their race, ethnicity, age, sex, or national origin. In the 1960s and 1970s, many states had separate schools where only students of a certain race or gender were able to study. However, the courts decided that these policies violated the civil rights of students who could not be admitted because of those rules. In 2017, the Trump administration began enacting a policy at border entries in El Paso that entailed separating undocumented parents and children as they entered the United States. They expanded that policy in 2018. Today, the government continues to try to reunite families who were separated during that time. The idea that Americans, indeed people in general, have fundamental rights and liberties was at the core of the arguments in favor of their independence. In writing the Declaration of Independence in 1776, Thomas Jefferson drew on the ideas of English philosopher John Locke to express the colonists' belief that they had certain inalienable or natural rights that no ruler had the power or authority to deny to their subjects. It was a scathing legal indictment of King George III for violating the colonists' liberties. Although the Declaration of Independence does not guarantee specific freedoms, its language was instrumental in inspiring many of the states to adopt protections for civil liberties and rights in their own constitutions, and in expressing principles of the founding era that have resonated in the United States since its independence. In particular, Jefferson's words, "All men are created equal," became the centerpiece of struggles for the rights of women and minorities. Civil liberties and the Constitution. The Constitution, as drafted in 1787, did not include a Bill of Rights, although the idea of including one was proposed and, after brief discussion, dismissed in the final week of the Constitutional Convention. The framers of the Constitution believed they faced much more pressing concerns than the protection of civil rights and liberties, most notably keeping the fragile Union together in the light of internal unrest and external threats. Moreover, the framers thought that they had adequately covered rights issues in the main body of the document. Indeed, the Federalists did include in the Constitution some protections against legislative acts that might restrict the liberties of citizens, based on the history of real and perceived abuses by both British kings and parliaments, as well as royal governors. In Article 1, Section 9, the Constitution limits the power of Congress in 3 ways: prohibiting the passage of bills of attainder, prohibiting ex post facto laws, and limiting the ability of Congress to suspend the writ of habeas corpus. A bill of attainder is a law that convicts or punishes someone for a crime without a trial, a tactic used fairly frequently in England against the king's enemies. Prohibition of such laws meant that the U.S. Congress cannot simply punish people who are unpopular or who seem to be guilty of crimes. An ex post facto law has a retroactive effect. It can be used to punish crimes that were not crimes at the time they were committed, or it can be used to increase the severity of the punishment after the fact. Finally, the writ of habeas corpus is used in our common law legal system to demand that a neutral judge decide whether someone has been lawfully detained. Particularly in times of war or even in response to threats against national security, the government has held suspected enemy agents without access to civilian courts, often without access to lawyers or a defense, seeking instead to try them before military tribunals or detain them indefinitely without a trial. For example, during the Civil War, President Abraham Lincoln detained suspected Confederate saboteurs and sympathizers in Union-controlled states and attempted to have them tried in military courts, leading the Supreme Court to rule in Ex parte Milligan that the government could not bypass the civilian court system in states where it was operating. In 1919, Justice Oliver Wendell Holmes was the lone dissenter in the Abrams v. United States decision that convicted 4 young anti-war activists for pamphleteering against U.S. involvement in the Russian Civil War, which now would be excused as a clear case of freedom of speech. During World War II, the Roosevelt administration interned Japanese Americans and had other suspected enemy agents, including U.S. citizens, tried by military courts rather than by the civilian justice system, a choice the Supreme Court upheld in Ex parte Quirin. More recently, in the wake of the 9/11 attacks on the World Trade Center and the Pentagon, the Bush and Obama administrations detained suspected terrorists captured both within and outside the United States and sought to avoid trials in civilian courts and surveilled U.S. citizens to detect threats. Hence, there have been times in our history when national security issues trumped individual liberties. Debate has always swirled over these issues. The Federalists reasoned that the limited set of named or enumerated powers of Congress, along with the limitations on those powers in Article 1, Section 9 of the Constitution, would suffice, and that no separate Bill of Rights was needed. Writing as Publius in Federalist No. 84, Alexander Hamilton argued that the Constitution was merely intended to regulate the general political interests of the nation, rather than contend with the regulation of every species of personal and private concerns. Hamilton went on to argue that listing some rights might actually be dangerous because it would provide a pretext for people to claim that rights not included in such a list were not protected. Later, James Madison, in his speech introducing the proposed amendments that would become the Bill of Rights, acknowledged another Federalist argument. It has been said that a Bill of Rights is not necessary because the establishment of this government has not repealed those declarations of rights which are added to the several state constitutions. Neither had the Articles of Confederation included a specific listing of rights, even if it was predictable that state governments would differ in what they would tolerate, grant, and prohibit among their citizens. Anti-Federalists argued that the Federalists' position was incorrect and perhaps even insincere. The Anti-Federalists believed provisions such as the so-called elastic clause in Article 1, Section 8 of the Constitution would allow Congress to legislate on matters well beyond those foreseen by the Constitution's authors. Thus, they held that a Bill of Rights was necessary. One of the Anti-Federalists, Brutus, whom most scholars believe to be Robert Yates, wrote, "The powers, rights, and authority granted to the general government by this Constitution are as complete with respect to every object to which they extend as that of any state government. It reaches to everything which concerns human happiness. Life, liberty, and property are under its control. There is the same reason, therefore, that the exercise of power in this case should be restrained within proper limits, as in that of the state governments." The experience of the past 2 centuries has suggested that the Anti-Federalists may have been correct in this regard. While the states retain a great deal of importance, the scope and powers of the national government are much broader today than in 1787, likely beyond even the imaginings of the Federalists themselves. The struggle to have rights clearly delineated and the decision of the framers to omit a Bill of Rights from the Constitution nearly derailed the ratification process. While some of the states were willing to ratify without any further guarantees, in some of the larger states, New York and Virginia in particular, the Constitution's lack of specified rights became a serious point of contention. The Constitution could go into effect with the support of only 9 states, but the Federalists knew it could not be effective without the participation of the largest states. To secure majorities in favor of ratification in New York and Virginia, as well as Massachusetts, they agreed to consider incorporating provisions suggested by the ratifying states as amendments to the Constitution. Ultimately, James Madison delivered on this promise by proposing a package of amendments in the First Congress, drawing from the Declaration of Rights in the Virginia State Constitution, suggestions from the ratification conventions, and other sources. Each of these were extensively debated in both houses of Congress and ultimately proposed as 12 separate amendments for ratification by the states. 10 of the amendments were successfully ratified by the requisite 75% of the states and became known as the Bill of Rights.
Rights and liberties protected by the first 10 amendments.
First Amendment.
Right to freedoms of religion and speech. Right to assemble and to petition the government for redress of grievances. Right to a free press.
Second Amendment.
Right to keep and bear arms to maintain a well-regulated militia.
Third Amendment.
Right to not house soldiers during time of war.
Fourth Amendment.
Right to be secure from unreasonable search and seizure.
Fifth Amendment.
Rights in criminal cases, including due process and indictment by grand jury for capital crimes, as well as the right not to testify against oneself.
Sixth Amendment.
Right to a speedy trial by an impartial jury.
Seventh Amendment.
Right to a jury trial in civil cases.
Eighth Amendment.
Right to not face excessive bail, excessive fines, or cruel and unusual punishment.
Ninth Amendment.
Rights retained by the people, even if they are not specifically enumerated by the Constitution.
10th Amendment.
States' rights to powers not specifically delegated to the federal government. Finding a middle ground. Debating the need for a Bill of Rights. One of the most serious debates between the Federalists and the Anti-Federalists was over the necessity of limiting the power of the new federal government with a Bill of Rights. As we saw in this section, the Federalists believed a Bill of Rights was unnecessary, and perhaps even dangerous to liberty, because it might invite violations of rights that weren't included in it. While the Anti-Federalists thought the national government would prove adept at expanding its powers and influence, and that citizens couldn't depend on the good judgment of Congress alone to protect their rights. As George Washington's call for a Bill of Rights in his first inaugural address suggested, while the Federalists ultimately had to add the Bill of Rights to the Constitution in order to win ratification, the Anti-Federalists' fear that the national government might intrude on civil liberties proved to be prescient. In 1798, at the behest of President John Adams during the quasi-war with France, Congress passed a series of 4 laws, collectively known as the Alien and Sedition Acts. These laws were drafted to allow the president to imprison or deport foreign citizens that he believed were dangerous to the peace and safety of the United States, and to restrict speech and newspaper articles critical of the federal government or its officials. The laws were primarily used against members and supporters of the opposition, the Democratic Republican Party. State laws and constitutions protecting free speech and freedom of the press proved ineffective in limiting this new federal power. Although the courts did not decide on the constitutionality of these laws at the time, most scholars believe the Sedition Act, in particular, would be ruled unconstitutional if it had remained in effect. 3 of the 4 laws were repealed in the Jefferson administration, but one, the Alien Enemies Act, remains on the books today. 2 centuries later, the issue of free speech and freedom of the press during times of international conflict remains a subject of intense public debate. Should the government be able to restrict or censor unpatriotic, disloyal, or critical speech in times of international conflict? What about from government whistleblowers or employees who leak sensitive information? How much freedom should journalists have to report on stories from the perspective of enemies or to repeat propaganda from opposing forces?
Extending the Bill of Rights to the states. In the decades following the Constitution's ratification, the Supreme Court declined to expand the Bill of Rights to curb the power of the states, most notably in the 1833 case of Barron v. Baltimore. In this case, which dealt with property rights under the Fifth Amendment, the Supreme Court unanimously decided that the Bill of Rights applied only to actions by the federal government, not state or local governments. Explaining the court's ruling, Chief Justice John Marshall wrote that it was incorrect to argue that the Constitution was intended to secure the people of the several states against the undue exercise of power by their respective state governments, as well as against that which might be attempted by their federal government. The festering issue of the rights of enslaved persons and the convulsions of the Civil War and its aftermath forced a re-examination of the prevailing thinking about the application of the Bill of Rights to the states. Soon after slavery was abolished by the 13th Amendment, state governments, particularly those in the former Confederacy, began to pass black codes that restricted the rights of formerly enslaved people, including the right to hold office, own land, or vote, relegating them to second-class citizenship. Angered by these actions, members of the radical Republican faction in Congress demanded that the black codes be overturned. In the short term, they advocated suspending civilian government in most of the southern states and replacing politicians who had enacted these discriminatory laws. Their long-term solution was to propose and enforce two amendments to the Constitution to guarantee the rights of freedmen and women. These became the 14th Amendment, which dealt with civil liberties and rights in general, and the 15th Amendment, which protected the right to vote in particular, though still not for women or Native Americans. With the ratification of the 14th Amendment in 1868, the scope and limits of civil liberties became clearer. First, the amendment says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States," which is a provision that echoes the Privileges and Immunities Clause in Article 4, Section 2 of the original Constitution, ensuring that states treat citizens of other states the same as their own citizens. To use an example from today, the punishment for speeding by an out-of-state driver cannot be made more severe than the punishment for an in-state driver. Legal scholars and the courts have extensively debated the meaning of this Privileges or Immunities Clause over the years, with some arguing that it was supposed to extend the entire Bill of Rights, or at least the first 8 amendments, to the states, and others arguing that only some rights are extended. In 1999, Justice John Paul Stevens, writing for a majority of the Supreme Court, argued in Sands v. Roe that the clause protects the right to travel from one state to another. More recently, Justice Clarence Thomas argued in the 2010 McDonald v. Chicago ruling that the individual right to bear arms applied to the states because of this clause. The second provision of the 14th Amendment pertaining to the application of the Bill of Rights to the states is the Due Process Clause, which famously reads, "Nor shall any state deprive any person of life, liberty, or property without due process of law." Like the Fifth Amendment, this clause refers to due process, a term that is interpreted to require both access to procedural justice, such as the right to a trial, as well as the more substantive implication that people be treated fairly and impartially by government officials. Although the text of the provision does not mention rights specifically, the courts have held in a series of cases that due process also implies that there are certain fundamental liberties that cannot be denied by the states. For example, in Sherbert v. Verner, 1963, the Supreme Court ruled that states could not deny unemployment benefits to an individual who turned down a job because it required working on the Sabbath. Beginning in 1897, the Supreme Court found that various provisions of the Bill of Rights protecting these fundamental liberties must be upheld by the states, even if their state constitutions and laws and the 10th Amendment itself do not protect them as fully as the Bill of Rights does, or at all. This means that there has been a process of selective incorporation of the Bill of Rights into the practices of the states. The Constitution effectively inserts parts of the Bill of Rights into state laws and constitutions, even though it doesn't do so explicitly. When cases arise to clarify particular issues and procedures, the Supreme Court decides whether state laws violate the Bill of Rights and are therefore unconstitutional. For example, under the Fifth Amendment, a person can be tried in federal court for a felony, a serious crime, only after a grand jury issues an indictment indicating that it is reasonable to try them. A grand jury is a group of citizens charged with deciding whether there's enough evidence of a crime to prosecute someone. The Supreme Court has ruled that states don't have to use grand juries as long as they ensure people accused of crimes are indicted using an equally fair process. Selective incorporation is an ongoing process. When the Supreme Court initially decided in 2008 that the Second Amendment protects an individual's right to keep and bear arms, it did not decide then that it was a fundamental liberty the states must uphold as well. It was only in the McDonald versus Chicago case 2 years later that the Supreme Court incorporated the Second Amendment into state law. Another area in which the Supreme Court gradually moved to incorporate the Bill of Rights regards censorship and the 14th Amendment. In Neer versus Minnesota, 1931, the court disagreed with state courts regarding censorship and ruled it unconstitutional except in rare cases.
Securing basic freedoms. Learning objectives. By the end of this section, you will be able to identify the liberties and rights guaranteed by the first 4 amendments to the Constitution, explain why in practice these rights and liberties are limited, explain why interpreting some amendments has been controversial.
We can broadly divide the provisions of the Bill of Rights into 3 categories. The First, Second, Third, and Fourth Amendments protect basic individual freedoms. The Fourth, partly, Fifth, Sixth, Seventh, and Eighth protect people suspected or accused of criminal activity or facing civil litigation. And the Ninth and 10th are consistent with the framers' view that the Bill of Rights is not necessarily an exhaustive list of all the rights people have and guarantees a role for state as well as federal government. The First Amendment protects the right to freedom of religious conscience and practice and the right to free expression, particularly of political and social beliefs. The Second Amendment, perhaps the most controversial today, protects the right to defend yourself in your home and other property, and, until the establishment of the National Guard, the collective right to self-defense as part of a militia. The Third Amendment prohibits the government from commandeering people's homes to house soldiers, particularly in peacetime. Finally, the Fourth Amendment prevents the government from searching one's person or property or taking evidence without a warrant issued by a judge, with certain exceptions. The First Amendment. The First Amendment is perhaps the most famous provision of the Bill of Rights. It is arguably also the most extensive, because it guarantees both religious freedoms and the right to express your views in public. Specifically, the First Amendment says, "Congress shall make no law respecting an establishment of religion, or prohibiting the free exercise thereof, or abridging the freedom of speech, or of the press, or the right to the people peaceably to assemble, and to petition the government for a redress of grievances." Given the broad scope of this amendment, it is helpful to break it into 2 major parts. The first portion deals with religious freedom. However, it actually protects 2 related sorts of freedom. First, it protects people from having a set of religious beliefs imposed on them by the government. And second, it protects people from having their own religious beliefs restricted by government authorities. The Establishment Clause. The first of these two freedoms is known as the Establishment Clause. Congress is prohibited from creating or promoting a state-sponsored religion. This now includes the states. When the United States was founded, most countries around the world had an established church or religion, an officially sponsored set of religious beliefs and values. In Europe, bitter wars were fought between and within states, often because the established church of one territory was in conflict with that of another. Wars and civil strife were common, particularly between states with Protestant and Catholic churches that had differing interpretations of Christianity. Even in recent years, the legacy of these wars remains, most notably in Ireland, where complications from Brexit have rekindled tensions between a mostly Catholic South and a largely Protestant North that were simmering for nearly a century. Many settlers in the United States came to this continent as refugees from such wars. Others came to find a place where they could follow their own religion with like-minded people in relative peace. Even if the early United States had wanted to establish a single-nation religion, the diversity of religious beliefs within and between the colonies would have made this quite impossible. Nonetheless, the differences were small. Most people were of European origin and professed some form of Christianity, although in private some of the founders, most notably Thomas Jefferson, Thomas Paine, and Benjamin Franklin, held what today would have been seen as more pluralistic, Unitarian, or deistic views. So for much of U.S. history, the Establishment Clause was not particularly important. The vast majority of citizens were Protestant Christians of some form. And since the federal government was relatively uninvolved in the day-to-day lives of the people, there was little opportunity for conflict. That said, there were some citizenship and office-holding restrictions on Jews within some of the states. Worry about state sponsorship of religion in the United States began to re-emerge in the latter part of the 19th century. An influx of immigrants from Ireland and Eastern and Southern Europe brought large numbers of Catholics. Fearing the new immigrants and their children would not assimilate, states passed laws forbidding government aid to religious schools. New religious organizations such as the Church of Jesus Christ of Latter-day Saints, Seventh-day Adventists, Jehovah's Witnesses, and many others also emerged, blending aspects of Protestant beliefs with other ideas and teachings at odds with the more traditional Protestant churches of the era. At the same time, public schooling was beginning to take root on a wide scale. Since most states had traditional Protestant majorities and most state officials were Protestants themselves, the public school curriculum incorporated many Protestant features. At times, these features would come into conflict with the beliefs of children from other Christian sects or from other religious traditions. The Establishment Clause today tends to be interpreted a bit more broadly than in the past. It not only forbids the creation of a Church of the United States or a Church of Ohio, it also forbids the government from favoring one set of religious beliefs over others, or favoring religion of any variety over non-religion. Thus, the government cannot promote, say, Islamic beliefs over Sikh beliefs, or belief in God over atheism or agnosticism. The key question that faces the courts is whether the Establishment Clause should be understood as imposing, in Thomas Jefferson's words, a wall of separation between church and state. In a 1971 case known as Lemon v. Kurtzman, the Supreme Court established the Lemon test for deciding whether a law or other government action that might promote a particular religious practice should be allowed to stand. The Lemon test has 3 criteria that must be satisfied for such a law or action to be found constitutional and remain in effect. Number 1. The action or law must not lead to excessive government entanglement with religion. In other words, policing the boundary between government and religion should be relatively straightforward and not require extensive effort by the government. Number 2. The action or law cannot either inhibit or advance religious practice. It should be neutral in its effects on religion. Number 3. The action or law must have some secular purpose. There must be some non-religious justification for the law. For example, imagine your state decides to fund a school voucher program that allows children to attend private and parochial schools at public expense. The vouchers can be used to pay for school books and transportation to and from school. Would this voucher program be constitutional? Let's start with the secular purpose prong of the test. Educating children is a clear, non-religious purpose, so the law has a secular purpose. The law would neither inhibit nor advance religious practice, so that prong would be satisfied. The remaining question, and usually the one on which court decisions turn, is whether the law leads to excessive government entanglement with religious practice. Given that transportation and school books generally have no religious purpose, there is little risk that paying for them would lead the state to much entanglement with religion. The decision would become more difficult if the funding were unrestricted in use, or helped to pay for facilities or teacher salaries. If that were the case, it might indeed be used for a religious purpose, and it would be harder for the government to ensure that it wasn't without audits or other investigations that could lead to too much government entanglement with religion. The use of education as an example is not an accident. In fact, many of the court's cases dealing with the Establishment Clause have involved education, particularly public education, because school-age children are considered a special and vulnerable population. Perhaps no subject affected by the First Amendment has been more controversial than the issue of prayer in public schools. Discussion about school prayer has been particularly fraught because in many ways it appears to bring the two religious liberty clauses into conflict with each other. The Free Exercise Clause, discussed below, guarantees the right of individuals to practice their religion without government interference. And while the rights of children are not as extensive in all areas as those of adults, the courts have consistently ruled that the Free Exercise Clause's guarantee of religious freedom applies to children as well. At the same time, however, government actions that require or encourage particular religious practices might infringe upon children's rights to follow their own religious beliefs, and thus, in effect, be unconstitutional establishments of religion. For example, a teacher, an athletic coach, or even a student reciting a prayer in front of a class, or leading students in prayer as part of the organized school activities, constitutes an illegal establishment of religion. Yet, a school cannot prohibit voluntary, non-disruptive prayer by its students because that would impair the free exercise of religion. So although the blanket statement that prayer in schools is illegal or unconstitutional is incorrect, the Establishment Clause does limit official endorsement of religion, including prayers organized or otherwise facilitated by school authorities, even as part of off-campus or extracurricular activities. But some laws that may appear to establish certain religious practices are allowed. For example, the courts have permitted religiously inspired blue laws that limit working hours or even shutter businesses on Sunday, the Christian day of rest, because by allowing people to practice their Christian faith, such rules may help ensure the health, safety, recreation, and general well-being of citizens. They have allowed restrictions on the sale of alcohol and sometimes other goods on Sunday for similar reasons. Such laws in Bergen County, New Jersey, and especially its borough of Paramus, shutter many retail stores every Sunday, despite Bergen having one of the largest concentrations of retail space in the nation and 5 large enclosed shopping malls. While various political figures, including former Governor Chris Christie, have proposed repealing the laws, town and county officials have vowed to keep them in place as a quality-of-life element. Many citizens support them, while others cite the difficulty in doing their own shopping and the impact on smaller retailers in their rationale for eliminating the restrictions. The meaning of the Establishment Clause has been controversial at times, because, as a matter of course, government officials acknowledge that we live in a society with vigorous religious practice where most people believe in God, even if we disagree on what God is. Disputes often arise over how much the government can acknowledge this widespread religious belief. The courts have generally allowed for a certain tolerance of what is described as ceremonial deism, an acknowledgement of God or a creator that generally lacks any substantive religious context. For example, the national motto, "In God We Trust," which appears on our coins and paper money, is seen as more an acknowledgement that most citizens believe in God than any serious effort by government officials to promote religious belief and practice. This reasoning has also been used to permit the inclusion of the phrase "under God" in the Pledge of Allegiance, a change that came about during the early years of the Cold War as a means of contrasting the United States with the godless Soviet Union. In addition, the courts have allowed some religiously motivated actions by government agencies, such as clergy delivering prayers to open city council meetings and legislative sessions, on the presumption that, unlike school children, adult participants can distinguish between the government's allowing someone to speak and endorsing that person's speech. Yet while some displays of religious codes, for example, 10 Commandments, are permitted in the context of showing the evolution of law over the centuries, in other cases these displays have been removed after state Supreme Court rulings. In Oklahoma, the courts ordered the removal of a 10 Commandments sculpture at the state capitol, when other groups, including Satanists and the Church of the Flying Spaghetti Monster, attempted to get their own sculptures allowed there. The Free Exercise Clause. The Free Exercise Clause, on the other hand, limits the ability of the government to control or restrict religious practices. This portion of the First Amendment regulates not the government's promotion of religion, but rather government suppression of religious beliefs and practices. Much of the controversy surrounding the Free Exercise Clause reflects the way laws or rules that apply to everyone might apply to people with particular religious beliefs. For example, can a Jewish police officer whose religious belief, if followed strictly, requires them to observe Shabbat, be compelled to work on a Friday night or during the day on Saturday? Or must the government accommodate this religious practice, even if it means the general law or rule in question is not applied equally to everyone? In the 1930s and 1940s, cases involving Jehovah's Witnesses demonstrated difficulty of striking the right balance. In addition to following their church's teaching that they should not participate in military combat, members refused to participate in displays of patriotism, including saluting the flag and reciting the Pledge of Allegiance. And they regularly engage in door-to-door evangelism to recruit converts. These activities have led to frequent conflict with local authorities. Jehovah's Witness children were punished in public schools for failing to salute the flag or recite the Pledge of Allegiance. And members attempting to evangelize were arrested for violating laws against door-to-door solicitation of customers. In early legal challenges brought by Jehovah's Witnesses, the Supreme Court was reluctant to overturn state and local laws that burdened their religious beliefs. However, in later cases, the court was willing to uphold the rights of Jehovah's Witnesses to proselytize and refuse to salute the flag or recite the pledge. The rights of conscientious objectors, individuals who claim the right to refuse to perform military service on the grounds of freedom of thought, conscience, or religion, have also been controversial, although many conscientious objectors have contributed service as non-combatant medics during wartime. To avoid serving in the Vietnam War, many people claimed to have a conscientious objection to military service on the basis that they believed this particular war was unwise or unjust. However, the Supreme Court ruled in Gillette v. United States that to claim to be a conscientious objector, a person must be opposed to serving in any war, not just some wars. Establishing a general framework for deciding whether a religious belief can trump general laws and policies has been a challenge for the Supreme Court. In the 1960s and 1970s, the court decided 2 cases in which it laid out a general test for deciding similar cases in the future. In both Sherbert v. Verner, a case dealing with unemployment compensation, and Wisconsin v. Yoder, which dealt with the right of Amish parents to homeschool their children, the court said that for a law to be allowed to limit or burden a religious practice, the government must meet two criteria. It must demonstrate that it had a compelling governmental interest in limiting that practice, and that the restriction was narrowly tailored. In other words, it must show that there was a very good reason for the law in question and that the law was the only feasible way of achieving that goal. This standard became known as the Sherbert test. Since the burden of proof in these cases was on the government, the Supreme Court made it very difficult for the federal and state governments to enforce laws against individuals that would infringe upon their religious beliefs. In 1990, the Supreme Court made a controversial decision, substantially narrowing the Sherbert test in Employment Division v. Smith, more popularly known as the Peyote case. This case involved two men who were members of the Native American Church, a religious organization that uses the hallucinogenic peyote plant as part of its sacraments. After being arrested for possession of peyote, the two men were fired from their jobs as counselors at a private drug rehabilitation clinic. When they applied for unemployment benefits, the state refused to pay, on the basis that they had been dismissed for work-related reasons. The men appealed the denial of benefits and were initially successful, since the state courts applied the Sherbert test and found that the denial of unemployment benefits burdened their religious beliefs. However, the Supreme Court ruled in a 6-3 decision that the compelling governmental interest standard should not apply. Instead, so long as the law was not designed to target a person's religious beliefs in particular, it was not up to the courts to decide that those beliefs were more important than the law in question. On the surface, a case involving the Native American Church seems unlikely to arouse much controversy. But because it replaced the Sherbert test with one that allowed more government regulation of religious practices, followers of other religious traditions grew concerned that state and local laws, even ones neutral on their face, might be used to curtail their religious practices. In 1993, in response to this decision, Congress passed a law known as the Religious Freedom Restoration Act, RFRA, which was followed in 2000 by the Religious Land Use and Institutionalized Persons Act, after part of the RFRA was struck down by the Supreme Court. In addition, since 1990, 21 states have passed RFRAs that include the Sherbert test in state law, and state court decisions in 11 states have enshrined the Sherbert test's compelling governmental interest interpretation of the Free Exercise Clause into state law. However, the RFRA itself has not been without its critics. While it has been relatively uncontroversial as applied to the rights of individuals, debate has emerged about whether businesses and other groups can be said to have religious liberty. In explicitly religious organizations such as an Orthodox union, congregation, or the Roman Catholic Church, it is fairly obvious members have a meaningful shared religious belief. But the application of the RFRA has become more problematic in businesses and nonprofit organizations whose owners or organizers may share a religious belief while the organization has some secular, non-religious purpose. Such a conflict emerged in the 2014 Supreme Court case known as Burwell v. Hobby Lobby. The Hobby Lobby chain of stores sells arts and craft merchandise at hundreds of stores, and its founder, David Green, is a fundamentalist Christian whose beliefs include opposition to abortion and contraception. Consistent with these beliefs, he used his business to object to a provision of the Patient Protection and Affordable Care Act, ACA or Obamacare, requiring employer-backed insurance plans to include no-charge access to the morning after pill, a form of emergency contraception, arguing that this requirement infringed on his conscience. Based in part on the federal RFRA, the Supreme Court agreed 5-4 with Green and Hobby Lobby's position that said that Hobby Lobby and other closely held businesses did not have to provide employees free access to emergency contraception or other birth control if doing so would violate the religious beliefs of the business owners. because there were other less restrictive ways the government could ensure access to these services for Hobby Lobby's employees, for example, paying them directly. In 2015, state RFRAs became controversial when individual and businesses that provided wedding services, for example, catering and photography, were compelled to provide these for same-sex weddings in states where the practice had been newly legalized. Proponents of state RFRA laws argued that people and businesses ought not be compelled to endorse practices that their religious beliefs hold to be immoral or indecent. They also indicated concerns that clergy might be compelled to officiate same-sex marriages against their religion's teachings. Opponents of RFRA laws argued that individuals and businesses should be required, per Obergefell v. Hodges, to serve same-sex marriages on an equal basis as a matter of ensuring the civil rights of gays and lesbian people, just as they would be obliged to cater or photograph an interracial marriage. In 2023, the Supreme Court ruled that a Colorado graphic artist was not obligated to create wedding websites for same-sex couples, despite a state law barring discrimination based on sexual orientation. It should be noted that religious organizations and clergy are not homogeneous in their view of marriage. For example, same-sex marriage is supported by Episcopalians, a sizable number of Methodists, and many leaders in the Jewish and Hindu faiths. Despite ongoing controversy, however, the courts have consistently found some public interests sufficiently compelling to override the Free Exercise Clause. For example, since the late 19th century, the courts have consistently held that people's religious beliefs do not exempt them from the general laws against polygamy, drug use, or human sacrifice. Yet, the public interest did not trump individual rights during the COVID-19 pandemic, when the Supreme Court overturned California's ban on indoor gatherings. Other potential acts in the name of religion that are also out of the question are drug use and human sacrifice. Freedom of expression. Although the remainder of the First Amendment protects 4 distinct rights, free speech, press, assembly, and petition, we generally think of these rights today as encompassing a right to freedom of expression, particularly since the world's technological evolution has blurred the lines between oral and written communication, for instance speech and press, in the centuries since the First Amendment was written and adopted. Controversies over freedom of expression were rare until the 1900s, even though government censorship was quite common. For example, during the Civil War, the Union Post Office refused to deliver newspapers that opposed the war or sympathized with the Confederacy, while allowing pro-war newspapers to be mailed. The emergence of photography and movies in particular led to new public concerns about morality, causing both state and federal politicians to censor lewd and otherwise inappropriate content. At the same time, writers became more ambitious in their subject matter by including explicit references to sex and using obscene language, leading to government censorship of books and magazines. Censorship reached its height during World War I. The United States was swept up in 2 waves of hysteria. Anti-German feeling was provoked by the actions of Germany and its allies leading up to the war, including the sinking of the RMS Lusitania and the Zimmermann Telegram, an effort by the Germans to conclude an alliance with Mexico against the United States. This concern was compounded in 1917 by the Bolshevik Revolution against the more moderate interim government of Russia. The leaders of the Bolsheviks, most notably Vladimir Lenin, Leon Trotsky, and Joseph Stalin, withdrew from the war against Germany and called for communist revolutionaries to overthrow the capitalist democratic governments in Western Europe and North America. Americans who vocally supported the communist cause or opposed the war often found themselves in jail. In Schenck v. United States, the Supreme Court ruled that people encouraging young men to dodge the draft could be imprisoned for doing so, arguing that recommending that people disobey the laws was tantamount to falsely shouting fire in a theater and causing a panic, and thus presented a clear and present danger to public order. Similarly, communists and other revolutionary anarchists and socialists during the Red Scare after the war were prosecuted under various state and federal laws for supporting the forceful or violent overthrow of the government. This general approach to political speech remained in place for the next 50 years. In the 1960s, however, the Supreme Court's ruling on free expression became more liberal in response to the Vietnam War and the growing anti-war movement. In a 1969 case involving the Ku Klux Klan, Brandenburg versus Ohio, the Supreme Court found that only speech or writing that constituted a direct call or plan to imminent lawless action, an illegal act in the immediate future, could be suppressed. The mere advocacy of a hypothetical revolution was not enough. The Supreme Court also found that various forms of symbolic speech, wearing clothing like an armband that carried a political symbol, or raising a fist in the air, for example, were subject to the same protections as written and spoken communication. More recently, symbolic speech related to the U.S. flag has engendered intense debate. Whether one should kneel during the national anthem or ought to be able to burn the U.S. flag are key questions. Freedom of the press is an important component of the right to free expression as well. In Neer versus Minnesota, an early case regarding press freedoms, the Supreme Court ruled that the government generally could not engage in prior restraint. That is, states and the federal government could not in advance prohibit someone from publishing something without a very compelling reason. This standard was reinforced in 1971 in the Pentagon Papers case, in which the Supreme Court found that the government could not prohibit the New York Times and Washington Post newspapers from publishing the Pentagon Papers. These papers included materials from a secret history of the Vietnam War that had been compiled by the military. More specifically, the papers were compiled at the request of Secretary of Defense Robert McNamara and provided a study of U.S. political and military involvement in Vietnam from 1945 to 1967. Daniel Ellsberg famously released passages of the papers to the press to show that the United States had secretly enlarged the scope of the war by bombing Cambodia and Laos, among other deeds, while lying to the American public about doing so. Although people who leak secret information to the media can still be prosecuted and punished, this does not generally extend to reporters and news outlets that pass that information to the public. The Edward Snowden case is another good case in point. Snowden himself, rather than those involved in promoting the information that he shared, is the object of criminal prosecution. Furthermore, the courts have recognized that government officials and other public figures might try to silence press criticism and avoid unfavorable news coverage by threatening a lawsuit for defamation of character. In the 1964 New York Times versus Sullivan case, the Supreme Court decided that public figures needed to demonstrate not only that a negative press statement about them was untrue, but also that the statement was published or made with either malicious intent or reckless disregard for the truth. This ruling made it much harder for politicians to silence potential critics or to bankrupt their political opponents through the courts. The right to freedom of expression is not absolute. Several key restrictions limit our ability to speak or publish opinions under certain circumstances. We have seen that the Constitution protects most forms of offensive and unpopular expression, particularly political speech. However, incitement of a criminal act, fighting words, and genuine threats are not protected. So, for example, you can't point at someone in front of an angry crowd and shout, "Let's beat that guy up!" And the Supreme Court has allowed laws that ban threatening symbolic speech, such as burning a cross on the lawn of an African American family's home. Finally, as we've just seen, defamation of character, whether in written form, libel, or spoken form, slander, is not protected by the First Amendment. So people who are subject to false accusations can sue to recover damages, although criminal prosecutions of libel and slander are uncommon. Another key exception to the right to freedom of expression is obscenity, acts or statements that are extremely offensive under current societal standards. Defining obscenity has been something of a challenge for the courts. Supreme Court Justice Potter Stewart famously said of obscenity, having watched pornography in the Supreme Court building, "I know it when I see it." Into the early 20th century, written work was frequently banned as being obscene, including works by noted authors such as James Joyce and Henry Miller, although today it is rare for the courts to uphold obscenity charges for written material alone. In 1973, the Supreme Court established the Miller test for deciding whether something is obscene. A, whether the average person applying contemporary community standards would find that the work, taken as a whole, appeals to the prurient interest. B, whether the work depicts or describes in a patently offensive way sexual conduct specifically defined by the applicable state law. And C, whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. However, the application of this standard has at times been problematic. In particular, the concept of contemporary community standards raises the possibility that obscenity varies from place to place. Many people in New York or San Francisco might not bat an eye at something people in Memphis or Salt Lake City would consider offensive. The one form of obscenity that has been banned almost without challenge is child pornography, although even in this area the courts have found exceptions. The courts have allowed censorship of less than obscene content when it is broadcast over the airwaves, particularly when it is available for anyone to receive. In general, these restrictions on indecency, equality of acts or statements that offend societal norms or may be harmful to minors, apply only to radio and television programming broadcast when children might be in the audience, although most cable and satellite channels follow similar standards for commercial reasons. An infamous case of televised indecency occurred during the halftime show of the 2004 Super Bowl, during a performance by singer Janet Jackson, in which part of her clothing was removed by fellow performer Justin Timberlake, revealing her right breast. The network responsible for the broadcast, CBS, was ultimately presented with a fine of $550,000 by the Federal Communications Commission, the government agency that regulates television broadcasting. However, CBS was not ultimately required to pay. On the other hand, in 1997, the NBC network showed a broadcast of Schindler's List, a film depicting events during the Holocaust in Nazi Germany, without any editing, so it included graphic nudity and depictions of violence. NBC was not fined or otherwise punished, suggesting there is no uniform standard for indecency. Similarly, in the 1990s, Congress compelled television broadcasters to implement a television rating system enforced by a V-chip in television and cable boxes, so parents could better control the television programming their children might watch. However, similar efforts to regulate indecent content on the internet to protect children from pornography have largely been struck down as unconstitutional. This outcome suggests that technology has created new avenues for obscene material to be disseminated. The Children's Internet Protection Act, however, requires K-12 schools and public libraries receiving internet access using special E-rate discounts to filter or block access to obscene material and other material deemed harmful to minors, with certain exceptions. The courts have also allowed laws that forbid or compel certain forms of expression by businesses, such as laws that require the disclosure of nutritional information on food and beverage containers and warning labels on tobacco products. The federal government requires the prices advertised for airline tickets to include all taxes and fees. Many states regulate advertising by lawyers, and in general, false or misleading statements made in connection with a commercial transaction can be illegal if they constitute fraud. Furthermore, the courts have ruled that although public school officials are government actors, the First Amendment freedom of expression rights of children attending public schools are somewhat limited. In particular, in Tinker v. Des Moines, 1969, and Hazelwood v. Kuhlmeyer, 1988, the Supreme Court has upheld restrictions on speech that creates substantial interference with school discipline or the rights of others, or is reasonably related to legitimate pedagogical concerns. For example, the content of school-sponsored activities, like school newspapers and speeches delivered by students, can be controlled, either for the purposes of instructing students in proper adult behavior or to deter conflict between students. Free expression includes the right to assemble peaceably and the right to petition government officials. This right even extends to members of groups whose views most people find abhorrent, such as American Nazis and the vehemently anti-LGBTQ Westboro Baptist Church, whose members have become known for their protests at the funerals of U.S. soldiers who have died fighting in the War on Terror. Free expression, although a broad right, is subject to certain constraints to balance it against the interests of public order, in particular the nature, place, and timing of protests, but not their substantive content, are subject to reasonable limits. The courts have ruled that, while people may peaceably assemble in a place that is a public forum, not all public property is a public forum. For example, the inside of a government office building or a college classroom, particularly while someone is teaching, is not generally considered a public forum. Rallies and protests on land that has other dedicated uses, such as roads and highways, can be limited to groups that have secured a permit in advance, and those organizing large gatherings may be required to give sufficient notice, so government authorities can ensure there is enough security available. However, any such regulation must be viewpoint neutral. The government may not treat one group differently than another because of its opinion or beliefs. For example, the government can't permit a rally by a group that favors a government policy, but forbid opponents from staging a similar rally. In a related 2024 case that could have implications for political expression, City of Grants Pass versus Johnson, the Supreme Court ruled on the rights of the homeless to live in encampments on subnational public lands, holding that removing and fining them was not cruel and unusual punishment, and pushing consideration of the right to gather to the states. The encampment question has been an important one around recent U.S. college campus protests pertaining to the Israeli-Palestinian conflict. Finally, there have been controversial situations in which government agencies have established free speech zones for protesters during political conventions, presidential visits, and international meetings in areas that are arguably selected to minimize their public audience or to ensure that the subjects of the protests do not have to encounter the protesters.
Milestone: burning the U.S. flag. Perhaps no act of symbolic speech has been as controversial in U.S. history as the burning of the flag. Citizens tend to revere the flag as a unifying symbol of the country, in much the same way most people in Britain would treat the reigning queen or king. States and federal government have long had laws protecting the flag from being desecrated, defaced, damaged, or otherwise treated with disrespect. Perhaps in part because of these laws, people who have wanted to drive home a point in opposition to U.S. government policies have found desecrating the flag a useful way to gain public and press attention to their cause. One such person was Gregory Lee Johnson, a member of various pro-communist and anti-war groups. In 1984, as part of a protest near the Republican National Convention in Dallas, Texas, Johnson set fire to a U.S. flag that another protester had torn from a flagpole. He was arrested, charged with desecration of a venerated object, among other offenses, and eventually convicted of that offense. However, in 1989, the Supreme Court decided in Texas v. Johnson that burning the flag was a form of symbolic speech protected by the First Amendment and found the law, as applied to flag desecration, to be unconstitutional. The court decision was strongly criticized, and Congress responded by passing a federal law, the Flag Protection Act, intended to overrule it. The act, too, was struck down as unconstitutional in 1990. Since then, Congress has tried and failed on several occasions to propose constitutional amendments allowing the states and federal government to recriminalize flag desecration. Should we amend the Constitution to allow Congress or the states to pass laws protecting the U.S. flag from desecration? Should we protect other national symbols as well, such as standing for the national anthem? Why or why not?
The Second Amendment. There has been an increased conflict over the Second Amendment in recent years due to school shootings and gun violence. As a result, gun rights have become a highly charged political issue. The text of the Second Amendment is among the shortest of those included in the Constitution. A well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. But the relative simplicity of its text has not kept it from controversy. Arguably, the Second Amendment has become controversial in large part because of its text. Is this amendment merely a protection of the right of the states to organize and arm a well-regulated militia for civil defense? Or is it a protection of a right of the people as a whole to individually bear arms? Before the Civil War, this would have been a nearly meaningless distinction. In most states at that time, white males of military age were considered part of the militia, liable to be called for service to put down rebellions or invasions, and the right to keep and bear arms was considered a common law right inherited from English law that predated the federal and state constitutions. The Constitution was not seen as a limitation on state power, and since the states expected all free men to keep arms as a matter of course, what gun control there was mostly revolved around ensuring enslaved people and their abolitionist allies didn't have guns. With the beginning of selective incorporation after the Civil War, debates over the Second Amendment were reinvigorated. In the meantime, as part of their black codes designed to reintroduce most of the trappings of slavery, several southern states adopted laws that restricted the carrying and ownership of weapons by formerly enslaved people. Despite acknowledging a common law individual right to keep and bear arms, in 1876 the Supreme Court declined, in United States versus Cruikshank, to intervene to ensure the states would respect it. In the following decades, states gradually began to introduce laws to regulate gun ownership. Federal gun control laws began to be introduced in the 1930s in response to organized crime, with stricter laws that regulated most commerce and trade in guns coming into force in the wake of the street protests of the 1960s. In the 1980s, following an assassination attempt on President Ronald Reagan, laws requiring background checks for prospective gun buyers were passed. During this period, the Supreme Court's decisions regarding the meaning of the Second Amendment were ambiguous at best. In United States v. Miller, the Supreme Court upheld the 1934 National Firearms Act's prohibition of sawed-off shotguns, largely on the basis that possession of such a gun was not related to the goal of promoting a well-regulated militia. This finding was generally interpreted as meaning that the Second Amendment protected the right of the states to organize a militia rather than an individual right, and thus lower courts generally found most firearm regulations, including some city and state laws that virtually outlawed private ownership of firearms, to be constitutional. However, in 2008, in a narrow 5-4 decision on District of Columbia v. Heller, the Supreme Court found that at least some gun control laws did violate the Second Amendment, and that this amendment does protect an individual's right to keep and bear arms, at least in some circumstances. In particular, for traditionally lawful purposes such as self-defense within the home. Because the District of Columbia is not a state, this decision immediately applied the right only to the federal government and territorial governments. 2 years later, in McDonald v. Chicago, the Supreme Court overturned the Cruikshank decision, 5-4, and again found that the right to bear arms was a fundamental right incorporated against the states, meaning that state regulation of firearms might, in some circumstances, be unconstitutional. In 2015, however, the Supreme Court allowed several of San Francisco's strict gun control laws to remain in place, suggesting that, as in the case of rights protected by the First Amendment, the courts will not treat gun rights as absolute. Elsewhere in the political system, the gun issue remains similarly unsettled. However, in the wake of especially traumatic shootings at a Las Vegas outdoor concert and at a school in Parkland, Florida, there was increased activism around gun control and community safety, especially among the young. The Third Amendment. The Third Amendment says in full, "No soldier shall, in time of peace, be quartered in any house, without the consent of the owner, nor in time of war, but in a manner to be prescribed by law." Most people consider this provision of the Constitution obsolete and unimportant. However, it is worthwhile to note its relevance in the context of the time. Citizens remembered having their cities and towns occupied by British soldiers and mercenaries during the Revolutionary War, and they viewed the British laws that required the colonists to house soldiers particularly offensive, to the point that it had been among the grievances listed in the Declaration of Independence. Today, it seems unlikely the federal government would need to house military forces and civilian lodgings against the will of property owners or tenants. However, perhaps in the same way we consider the Second and Fourth Amendments, we can think of the Third Amendment as reflecting a broader idea that our homes lie within a zone of privacy that government officials should not violate unless absolutely necessary. The Fourth Amendment. The Fourth Amendment sits at the boundary between general individual freedoms and the rights of those suspected of crimes. We saw earlier that perhaps it reflects James Madison's broader concern about establishing an expectation of privacy from government intrusion at home. Another way to think about the Fourth Amendment is that it protects us from overzealous efforts by law enforcement to root out crime by ensuring that police have good reason before they intrude on people's lives with criminal investigations. The text of the Fourth Amendment is as follows: "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue, but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." The amendment places limits on both searches and seizures. Searches are efforts to locate documents and contraband. Seizures are taking of these items by the government for use as evidence in a criminal prosecution, or in the case of a person, the detention or taking of the person into custody. In either case, the amendment indicates that government officials are required to apply for and receive a search warrant prior to a search or seizure. This warrant is a legal document signed by a judge, allowing police to search and or seize persons or property. Since the 1960s, however, the Supreme Court has issued a series of rulings limiting the warrant requirement in situations where a person can be said to lack a reasonable expectation of privacy outside the home. Police can also search and or seize people or property without a warrant if the owner or renter consents to the search, if there is a reasonable expectation that evidence may be destroyed or tampered with before a warrant can be issued, for instance, exigent circumstances, or if the items in question are in plain view of government officials. Furthermore, the courts have found that police do not generally need a warrant to search the passenger compartment of a car, or to search people entering the United States from another country. When a warrant is needed, law enforcement officers do not need enough evidence to secure a conviction, but they must demonstrate to a judge that there is probable cause to believe a crime has been committed or evidence will be found. Probable cause is the legal standard for determining whether a search or seizure is constitutional or a crime has been committed. It is a lower threshold than the standard of proof at a criminal trial. Critics have argued that this requirement is not very meaningful because law enforcement officers are almost always able to get a search warrant when they request one. On the other hand, since we wouldn't expect the police to waste their time or a judge's time trying to get a search warrants that are unlikely to be granted, perhaps the high rate at which they get them should not be so surprising. The use of no-knock warrants, based on the premise that a suspect would destroy drug evidence, has recently been curtailed after the wrongful killing of Breonna Taylor by police serving such a warrant. What happens if the police conduct an illegal search or seizure without a warrant and find evidence of a crime? In the 1961 Supreme Court case Mapp v. Ohio, the court decided that evidence obtained without a warrant that didn't fall under one of the exceptions mentioned above could not be used as evidence in a state criminal trial, giving rise to the broad application of what is known as the exclusionary rule, which was first established in 1914 on a federal level in Weeks v. United States. The exclusionary rule doesn't just apply to evidence found or to items or people seized without a warrant or falling under the exception noted above. It also applies to any evidence developed or discovered as a result of the illegal search or seizure. For example, if police search your home without a warrant, find bank statements showing large cash deposits on a regular basis, and discover you are engaged in some other crime in which they were previously unaware, for instance, blackmail, drugs, or prostitution, they can neither use the bank statements as evidence of criminal activity nor prosecute you for the crimes they discovered during the illegal search. This extension of the exclusionary rule is sometimes called the fruit of the poisonous tree, because just as the metaphorical tree, that is, the original search or seizure, is poisoned, so is anything that grows out of it. However, like the requirement for a search warrant, the exclusionary rule does have exceptions. The courts have allowed evidence to be used that was obtained without the necessary legal procedures in good circumstances where police executed warrants they believed were correctly granted, but in fact were not. Good faith exception. And when the evidence would have been found anyway, had they followed the law. Inevitable discovery. The requirement of probable cause also applies to arrest warrants. A person cannot generally be detained by police or taken into custody without a warrant, although most states allow police to arrest someone suspected for a felony crime without a warrant so long as probable cause exists. And police can arrest people for minor crimes or misdemeanors they have witnessed themselves. The Supreme Court's 2012 and 2018 decisions in United States v. Jones and Carpenter v. United States extended the prohibition of illegal search and seizure to warrantless location tracking, either by installing a GPS device, as in the Jones case, or by accessing that information provided to cellular companies, as in Carpenter.
.3 The Rights of Suspects. Learning Objectives. By the end of this section, you will be able to identify the rights of those suspected or accused of criminal activity, explain how Supreme Court decisions transform the rights of the accused, explain why the Eighth Amendment is controversial regarding capital punishment.
In addition to protecting the personal freedoms of individuals, the Bill of Rights protects those suspected or accused of crimes from various forms of unfair or unjust treatment. The prominence of these protections in the Bill of Rights may seem surprising. Given the colonist experience of what they believe to be unjust rule by British authorities, however, and the use of the legal system to punish rebels and their sympathizers for political offenses, the impetus to ensure fair, just, and impartial treatment to everyone accused of a crime, no matter how unpopular, is perhaps more understandable. What is more, the revolutionaries and the eventual framers of the Constitution wanted to keep the best features of English law as well. In addition to the protections outlined in the Fourth Amendment, which largely pertain to investigations conducted before someone has been charged with a crime, the next four amendments pertain to those suspected, accused, or convicted of crimes, as well as people engaged in other legal disputes. At every stage of the legal process, the Bill of Rights incorporates protections for these people. The Fifth Amendment. Many of the provisions dealing with the rights of the accused are included in the Fifth Amendment, Accordingly, it is one of the longest in the Bill of Rights. The Fifth Amendment states in full, "No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia when in actual service, in time of war or public danger, nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property without due process of law, nor shall private property be taken for public use without just compensation." The first clause requires that serious crimes be prosecuted only after an indictment has been issued by a grand jury. However, several exceptions are permitted as a result of the evolving interpretation and understanding of this amendment by the courts, given the Constitution is a living document. First, the courts have generally found this requirement to apply only to felonies. Less serious crimes can be tried without a grand jury proceeding. Second, this provision of the Bill of Rights does not apply to the states because it has not been incorporated. Many states instead require a judge to hold a preliminary hearing to decide whether there is enough evidence to hold a full trial. Finally, members of the armed forces who are accused of crimes are not entitled to a grand jury proceeding. The Fifth Amendment also protects individuals against double jeopardy, a process that subjects a suspect to prosecution twice for the same criminal act. No one who has been acquitted, found not guilty of a crime, can be prosecuted again for that crime. But the prohibition against double jeopardy has its own exceptions. The most notable is that it prohibits a second prosecution only at the same level of government, federal or state, as the first. The federal government can try you for violating federal law, even if a state or local court finds you not guilty of the same action. For example, in the early 1990s, several Los Angeles police officers accused of brutally beating motorist Rodney King during his arrest were acquitted of various charges in a state court, but some were later convicted in a federal court of violating King's civil rights. The double jeopardy rule does not prevent someone from recovering damages in a civil case, a legal dispute between individuals over a contract or compensation for an injury that results from a criminal act, even if the person accused of that act is found not guilty. One famous case from the 1990s involved former football star and television personality O.J. Simpson. Simpson, although acquitted of the murders of his ex-wife Nicole Brown and her friend Ron Goldman in a criminal court, was later found to be responsible for their deaths in a subsequent civil case, and as a result was forced to forfeit most of his wealth to pay damages to their families. Perhaps the most famous provision of the Fifth Amendment is its protection against self-incrimination, or the right to remain silent. This provision is so well known that we have a phrase for it, taking the fifth. People have the right not to give evidence in court or to law enforcement officers that might constitute an admission of guilt or responsibility for a crime. Moreover, in a criminal trial, if someone does not testify in their own defense, the prosecution cannot use that failure to testify as evidence of guilt or imply that an innocent person would testify. This provision became embedded in the public consciousness following the court's 1966 ruling in Miranda v. Arizona, whereby suspects were required to be informed of their most important rights, including the right against self-incrimination, before being interrogated in police custody. However, contrary to some media depictions of the Miranda warning, law enforcement officials do not necessarily have to inform suspects of their rights before they are questioned in situations where they are free to leave. Like the 14th Amendment's Due Process Clause, the Fifth Amendment prohibits the federal government from depriving people of their life, liberty, or property without due process of law. Recall that due process is a guarantee that people will be treated fairly and impartially by government officials when the government seeks to fine or imprison them or take their personal property away from them. The courts have interpreted this provision to mean that government officials must establish consistent, fair procedures to decide when people's freedoms are limited. In other words, citizens cannot be detained, their freedom limited, or their property taken arbitrarily or on a whim by police or other government officials. As a result, an entire body of procedural safeguards comes into play for the legal prosecution of crimes. However, the Patriot Act, passed into law after the 9/11 terrorist attacks, somewhat altered this notion. The final provision of the Fifth Amendment has little to do with crime at all. The Takings Clause says that private property cannot be taken for public use without just compensation. This provision, along with the Due Process Clause's provisions limiting the taking of property, can be viewed as a protection of individuals' economic liberty, their right to obtain, use, and trade tangible and intangible property for their own benefit. For example, you have the right to trade your knowledge, skills, and labor for money through work or the use of your property, or trade money or goods for other things of value, such as clothing, housing, education, or food. A significant recent controversy over economic liberty has been sparked by cities and states' use of the power of eminent domain to take property for redevelopment. Traditionally, the main use of eminent domain was to obtain property for transportation corridors, like railroads, highways, canals and reservoirs and pipelines, which require fairly straight routes to be efficient. Because any single property owner could effectively block a particular route or extract an unfair price for land if it was the last piece needed to assemble a route, there are reasonable arguments for using eminent domain as a last resort in these circumstances, particularly for projects that convey substantial benefits to the public at large. However, increasingly, eminent domain has been used to allow economic development, with beneficiaries ranging from politically connected big businesses, such as car manufacturers building new factories, to highly profitable sports teams taking ever more luxurious stadiums. And while we traditionally think of property owners as relatively well-off people who can fend for themselves in the political system, and whose rights don't necessarily need protecting, these cases frequently pit lower and middle-class homeowners against multinational corporations or multimillionaires with the ear of city and state officials. In a notorious 2005 case, Kelo versus City of New London, the Supreme Court sided with municipal officials taking homes in a middle-class neighborhood to obtain land for a large pharmaceutical company's corporate campus. Ultimately, the campus was not built on the seized land, and the case led to a public backlash against the use of eminent domain and legal changes in many states, making it harder for cities to take property from one private party and give it to another for economic redevelopment purposes. Eminent domain has once again become a salient issue in the context of the Trump administration's attempt to use the doctrine to seize several parcels of private property for the proposed border wall. Some disputes over economic liberty have gone beyond the idea of eminent domain. In the past few years, companies seeking to offer profitable services online, such as direct sales by electric car manufacturer Tesla Motors, on-demand ride-sharing services like Lyft and Uber, and short-term property rentals through companies like Airbnb, have led to conflict with states and cities trying to regulate these businesses, and with incumbent service providers such as hotels and taxicabs. In the absence of new public policies to clarify rights, the path forward is often determined through norms established by governments or by court cases. Sometimes, however, the legislative process seeks to clarify or improve the interpretation and application of amendments. The Fifth Amendment Integrity Restoration Act is aimed at reducing the practice of civil forfeiture, in which government and law enforcement entities seize property of people suspected of crimes prior to conviction and sometimes without bringing formal charges. The government can take financial assets, jewelry, vehicles, art, and other items of value. The bipartisan bill, backed by organizations ranging from the conservative-leaning Heritage Foundation to the ACLU, would reduce what its Senate sponsors, Rand Paul and Cory Booker, refer to as policing for profit. Civil forfeiture was a mainstay of the war on drugs and contributed to the mass incarceration of people of color. It can be economically damaging, even for those who are never charged or convicted, because in many cases, seized property is not returned to its owner. Various court cases have ruled on aspects of the practice, but have not eliminated it decisively, leaving the opportunity for a new law to address it. The Sixth Amendment. Once someone has been charged with a crime and indicted, the next stage in a criminal case is typically the trial itself, unless a plea bargain is reached. The Sixth Amendment contains the provisions that govern criminal trials. In full, it states, "In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with the witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense." The first of these guarantees is the right to have a speedy public trial by an impartial jury. Although there is no absolute limit on the length of time that may pass between an indictment and a trial, the Supreme Court has said that excessively lengthy delays may be justified and balanced against the potential harm to the defendant. In effect, the speedy trial requirement protects people from being detained indefinitely by the government. Yet the courts have ruled that there are exceptions to the public trial requirement. If a public trial would undermine the defendant's right to a fair trial, it can be held behind closed doors. While prosecutors can request closed proceedings only in certain narrow circumstances, generally to protect witnesses from retaliation or to guard classified information, in general, a prosecution must also be made in the state and district where the crime was committed. However, people accused of crimes may ask for a change of venue for their trial if they believe pre-trial publicity or other factors make it difficult or impossible for them to receive a fair trial where the crime occurred. Most people accused of crimes decline their right to a jury trial. This choice is typically the result of a plea bargain, an agreement between the defendant and the prosecutor in which the defendant pleads guilty to the charges in question, or perhaps to less serious charges, in exchange for a more lenient punishment than they might receive if convicted after a full trial. There are a number of reasons why this might happen. The evidence against the accused may be so overwhelming that conviction is a near certainty, so the accused might decide that avoiding the more serious penalty, perhaps even the death penalty, is better than taking the small chance of being acquitted after a trial. Someone accused of being part of a larger crime or criminal organization might agree to testify against others in exchange for a lighter punishment. At the same time, prosecutors might want to ensure a win in a case that might not hold up in court by securing convictions for offenses they know they can prove, while avoiding a lengthy trial on other charges they might lose. The requirement that a jury be impartial is a critical requirement of the Sixth Amendment. Both the prosecution and defense are permitted to reject potential jurors who they believe are unable to fairly decide the case without prejudice. However, the courts have also said that the composition of the jury as a whole may in itself be prejudicial, so potential jurors may not be rejected simply because of their race or sex, for example. The Sixth Amendment guarantees the right of those accused of crimes to present witnesses in their own defense, if necessary compelling them to testify, and to confront and cross-examine witnesses presented by the prosecution. In general, the only testimony acceptable in a criminal trial must be given in a courtroom and be subject to cross-examination. Hearsay, or testimony by one person about what another person has said, is generally inadmissible, although hearsay may be presented as evidence when it is an admission of guilt by the defendant or a dying declaration by a person who's passed away. Although both sides in a trial have the opportunity to examine and cross-examine witnesses, the judge may exclude testimony deemed irrelevant or prejudicial. Finally, the Sixth Amendment guarantees the right of those accused of crimes to have the assistance of an attorney in their defense. Historically, many states did not provide attorneys to those accused of most crimes who could not afford one themselves. And even when an attorney was provided, their assistance was often inadequate at best. This situation changed as a result of the Supreme Court's decision in Gideon v. Wainwright, 1963. Clarence Gideon, a poor drifter, was accused of breaking into and stealing money and other items from a pool hall in Panama City, Florida. Denied a lawyer, Gideon was tried and convicted and sentenced to a 5-year prison term. While in prison and still without assistance of a lawyer, he drafted a handwritten appeal and sent it to the Supreme Court, which agreed to hear his case. The justices unanimously ruled that Gideon and anyone else accused of a serious crime was entitled to the assistance of a lawyer, even if they could not afford one, as part of the general due process right to a fair trial. The Supreme Court later extended the Gideon v. Wainwright ruling to apply to any case in which an accused person faced the possibility of loss of liberty, even for one day. The courts have also overturned convictions in which people have incompetent or ineffective lawyers through no fault of their own. The Gideon ruling has led to an increased need for professional public defenders, lawyers who are paid by the government to represent those who cannot afford an attorney themselves. Although some states instead require practicing lawyers to represent poor defendants on a pro bono basis, essentially donating their time and energy to the case.
Insider perspective. Criminal justice. Theory meets practice. Typically, a person charged with a serious crime will have a brief hearing before a judge to be informed of the charges against the person, to be made aware of the right to counsel, and to enter a plea. Other hearings may be held to decide on the admissibility of evidence seized or otherwise obtained by prosecutors. If the two sides cannot agree on a plea bargain during this period, the next stage is the selection of a jury. A pool of potential jurors is summoned to the court and screened for impartiality, with the goal of seating 12 in most states and 1 or 2 alternates. All hear the evidence in the trial, and unless an alternate must serve, the original 12 decide whether the evidence overwhelmingly points towards guilt or innocence beyond a reasonable doubt. In the trial itself, the lawyers for the prosecution and defense make opening arguments, followed by testimony by witnesses for the prosecution and any cross-examination, and then testimony by witnesses for the defense, including the defendant if the defendant chooses. Additional prosecution witnesses may be called to rebut testimony by the defense. Finally, both sides make closing arguments. The judge then issues instructions to the jury, including an admonition not to discuss the case with anyone outside the jury room. The jury members leave the courtroom to enter the jury room and begin their deliberations. The jurors pick a foreman or forewoman to coordinate their deliberations. They may ask to review evidence or to hear transcripts of testimony. They deliberate in secret, and their decision must be unanimous. If they are unable to agree on a verdict after extensive deliberation, a mistrial may be declared, which in effect requires the prosecution to try the case all over again. A defendant found not guilty of all charges will be immediately released unless other charges are pending. For instance, the defendant is wanted for a crime in another jurisdiction. If the defendant is found guilty of one or more offenses, the judge will choose an appropriate sentence based on the law and the circumstances. In the federal system, this sentence will typically be based on guidelines that assign point values to various offenses and facts in the case. If the prosecution is pursuing the death penalty, the jury will decide whether the defendant should be subject to capital punishment or life imprisonment. The reality of court procedure is much less dramatic and exciting than what is typically portrayed in television shows and movies. Nonetheless, most Americans will participate in the legal system at least once in their lives, as a witness, juror, or defendant. Have you or any member of your family served on a jury? If so, was the experience a positive one? Did the trial proceed as expected? If you haven't served on a jury, is it something you look forward to? Why or why not?
The Seventh Amendment. The Seventh Amendment deals with the rights of those engaged in civil disputes. disagreements between individuals or businesses in which people are typically seeking compensation for some harm caused. For example, in an automobile accident, the person responsible is compelled to compensate any others, either directly or through their insurance company. Much of the work of the legal system consists of efforts to resolve civil disputes. The Seventh Amendment in full reads, "In suits at common law, where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law." Because of this provision, all trials in civil cases must take place before a jury unless both sides waive their right to a jury trial. However, this right is not always incorporated. In many states, civil disputes, particularly those involving small sums of money, which may be heard by a dedicated small claims court, need not be tried in front of a jury and may instead be decided by a judge working alone. The Seventh Amendment limits the ability of judges to reconsider questions of fact rather than of law that were originally decided by a jury. For example, if a jury decides a person was responsible for an action and the case is appealed, the appeals judge cannot decide someone else was responsible. This preserves the traditional common law distinction that judges are responsible for deciding questions of law, while jurors are responsible for determining the facts of a particular case. The Eighth Amendment. The Eighth Amendment says in full, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Bail is a payment of money that allows a person accused of a crime to be freed pending trial. If you make bail in a case and do not show up for your trial, you will forfeit the money you paid. Since many people cannot afford to pay bail directly, they may instead get a bail bond, which allows them to pay a fraction of the money, typically 10%, to a person who sells bonds and who pays the full bail amount. In most states, the bond seller makes money because the defendant does not get back the money for the bond, and most people show up for their trials. However, people believed likely to flee or who represent a risk to the community while free may be denied bail and held in jail until their trial takes place. It is rare for bail to be successfully challenged for being excessive. The Supreme Court has defined an excessive fine as one so grossly excessive as to amount to deprivation of property without due process of law, or grossly disproportional to the gravity of a defendant's offense. Historically, the courts have rarely struck down fines as excessive, though California and other states have recently passed legislation seeking to reform the more discriminatory aspects of the bail system. The most controversial provision of the Eighth Amendment is the ban on cruel and unusual punishments. Various torturous forms of execution common in the past, drawing and quartering, burning people alive, and the electric chair, are prohibited by this provision. Recent controversies over lethal injections and firing squads demonstrate that the topic of whether and how to execute is still very much alive. The Dutch producer of one of the chemicals in the most common lethal injection cocktail recently refused to export it to the United States when it was shown to protract the dying process for some inmates, maintaining consciousness, prolonging suffering, and paralyzing response. In a 2021 case, one death row prisoner lost an appeal to request death by firing squad in lieu of lethal injection. While the Supreme Court has never established a definitive test for what constitutes a cruel and unusual punishment, it has generally allowed most penalties short of death for adults, even when the punishment appears disproportionate or excessive to outside observers. In recent years, the Supreme Court has issued a series of rulings substantially narrowing the application of the death penalty. As a result, defendants who have intellectual disabilities may not be executed. Defendants who were under 18 when they committed an offense that would otherwise be subject to the death penalty may not be executed. The court has generally rejected the application of the death penalty to crimes that did not result in the death of another human being, most notably in the case of rape. And while permitting the death penalty to be applied to murder in some cases, the Supreme Court has generally struck down laws that require the application of the death penalty in certain circumstances. Still, the United States is among 10 countries with the most executions worldwide, with the Trump Justice Department pushing through a flurry of 13 executions in the last 4 months of his administration, breaking with the 130-year-old precedent of pausing executions amid a presidential transition. At the same time, however, it appears that the public mood may have shifted somewhat against the death penalty, perhaps due in part to an overall decline in violent crime. The re-examination of past cases through DNA evidence has revealed dozens in which people were wrongfully executed. For example, Claude Jones was executed for murder based on 1990-era DNA testing of a single hair that was determined at the time to be his, but that, with better DNA testing technology, was later found to be that of the victim. Perhaps as a result of this and other cases, 7 additional states have abolished capital punishment since 2007. As of 2015, 19 states and the District of Columbia no longer apply the death penalty in new cases, and several other states do not carry out executions despite sentencing people to death. It remains to be seen whether this gradual trend toward the elimination of the death penalty by the states will continue, or whether the Supreme Court will eventually decide to follow former Justice Harry Blackmun's decision to no longer tinker with the machinery of death and abolish it completely.
.4 Interpreting the Bill of Rights. Learning objectives. By the end of this section, you will be able to describe how the 9th and 10th Amendments reflect on our other rights, identify the 2 senses of the right to privacy embodied in the Constitution, explain the controversy over privacy when applied to abortion and same-sex relationships.
As this chapter has suggested, the provisions of the Bill of Rights have been interpreted and reinterpreted repeatedly over the past 2 centuries. However, the first 8 amendments are largely silent on the status of traditional common law, which was the legal basis for many of the natural rights claimed by the framers in the Declaration of Independence. These amendments largely reflect the worldview of the time in which they were written. New technology, societal norms, and economic realities furnished challenges that fail to fit neatly into the framework established in the late 18th century. In this section, we consider the final 2 amendments of the Bill of Rights and the way they affect our understanding of the Constitution as a whole. Rather than protecting specific rights and liberties, the 9th and 10th Amendments indicate how the Constitution and the Bill of Rights should be interpreted and lay out the residual powers of the state governments. We will also examine privacy rights, an area the Bill of Rights does not address directly. Rather, the emergence of defined privacy rights demonstrates how the 9th and 10th Amendments have been applied to expand the scope of rights protected by the Constitution. The 9th Amendment. We saw above that James Madison and the other framers were aware they might endanger some rights if they listed a few in the Constitution and omitted others. To ensure that those interpreting the Constitution would recognize that the listing of freedoms and rights in the Bill of Rights was not exhaustive, the 9th Amendment states, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." These rights retained by the people include the common law and natural rights inherited from the laws, traditions, and past court decisions of England. To this day, we regularly exercise and take for granted rights that aren't written down in the federal Constitution, like the right to marry, the right to seek opportunities for employment and education, and the right to have children and raise a family. Supreme Court justices over the years have interpreted the 9th Amendment in different ways, with some arguing that it was intended to extend the rights protected by the Constitution to those natural and common law rights, and others arguing that it does not prohibit states from changing their constitutions and laws to modify or limit those rights as they see fit. Critics of a broad interpretation of the Ninth Amendment point out that the Constitution provides ways to protect newly formalized rights through the amendment process. For example, in the 19th and 20th centuries, the right to vote was gradually expanded by a series of constitutional amendments, the 15th and 19th, even though at times this expansion was the subject of great public controversy. However, supporters of a broad interpretation of the Ninth Amendment point out that the rights of the people, particularly people belonging to political or demographic minorities, should not be subject to the whims of popular majorities. One right the courts have said may be at least partially based on the Ninth Amendment is a general right to privacy, discussed later in the chapter. The 10th Amendment. The 10th Amendment is as follows. The powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. Unlike the other provisions of the Bill of Rights, this amendment focuses on power rather than rights. The courts have generally read the 10th Amendment as merely stating, as Chief Justice Harlan Stone put it, a truism that all is retained which has not been surrendered. In other words, rather than limiting the power of the federal government in any meaningful way, it simply restates what is made obvious elsewhere in the Constitution. The federal government has both enumerated and implied powers. But where the federal government does not, or chooses not to exercise power, the states may do so. Others read this final "or" as capturing the essential question of U.S. political history. Do the states who agreed to unite in a federal system remain sovereign? Or, once united, is it the federal government's responsibility to protect the power of the people, including against states that might infringe upon them? At times, politicians and state governments have argued that the 10th Amendment means states can engage in interposition or nullification by blocking federal government laws and actions they deem to exceed the constitutional powers of the national government. But the courts have rarely been sympathetic to these arguments, except when the federal government appears to be directly requiring state and local officials to do something. For example, in 1997, the Supreme Court struck down part of a federal law that required state and local law enforcement to participate in conducting background checks for prospective gun purchasers. While in 2012, the court ruled that the government could not compel states to participate in expanding the joint state-federal Medicaid program by taking away all their existing Medicaid funding if they refused to do so. However, the 10th Amendment also allows states to guarantee rights and liberties more fully or extensively than the federal government does, or to include additional rights. For example, many state constitutions guarantee the right to a free public education. Several states give victims of crimes certain rights, and 18 states include the right to hunt game and/or fish. A number of state constitutions explicitly guarantee equal rights for men and women. Starting with Wyoming in 1869, some states permitted women to vote before the 19th Amendment secured the franchise for all women in 1920. Similarly, people aged 18 to 20 could vote in a few states before the 26th Amendment came into force in 1971. As we will see below, several states also explicitly recognize a right to privacy. State courts at times have interpreted state constitutional provisions to include broader protections for basic liberties than their federal counterparts. For example, though people do not generally have the right to free speech and assembly on private property owned by others without their permission, California's constitutional protection of freedom of expression was extended to portions of some privately owned shopping centers by the state's Supreme Court. These state protections do not extend the other way, however. If the federal government passes a law or adopts a constitutional amendment that restricts rights or liberties, or a Supreme Court decision interprets the Constitution in a way that narrows these rights, the state's protection no longer applies. For example, if Congress decided to outlaw hunting and fishing, and the Supreme Court decided this law was a valid exercise of federal power, the state constitutional provisions that protect the right to hunt and fish would effectively be meaningless. More concretely, federal laws that control weapons and drugs override state laws and constitutional provisions that otherwise permit them. While federal marijuana policies are not strictly enforced, state-level marijuana policies in Colorado and Washington provide a prominent exception to that clarity.
Get connected. Student-led constitutional change. Although the United States has not had a national constitutional convention since 1787, the states have generally been much more willing to revise their constitutions. In 1998, two politicians in Texas decided to do something a little bit different. They enlisted the help of college students at Angelo State University to draft a completely new constitution for the state of Texas, which was then formally proposed to the state legislature. Although the proposal failed, it was certainly a valuable learning experience for the students who took part. Each state has a different process for changing its constitution. In some, like California and Mississippi, voters can propose amendments to their state constitution directly, bypassing the state legislature. In others, such as Tennessee and Texas, the state legislature controls the process of initiation. The process can affect the sorts of amendments likely to be considered. It shouldn't be surprising, for example, that amendments limiting the number of terms legislators can serve in office have been much more common in states where the legislators themselves have no say in whether such provisions are adopted. What rights or liberties do you think ought to be protected by your state constitution that aren't already? Or would you get rid of some of these protections instead? Find a copy of your current state constitution, read through it, and decide. Then find out what steps would be needed to amend your state's constitution to make the changes you would like to see.
The right to privacy. Although the term privacy does not appear in the Constitution or Bill of Rights, scholars have interpreted several Bill of Rights provisions as an indication that James Madison and Congress sought to protect a common law right to privacy as it would have been understood in the late 18th century, a right to be free of government intrusion into our personal life, particularly within the bounds of the home. For example, one could see the Second Amendment as standing for the common law right to self-defense in the home, the Third Amendment as a statement that government soldiers should not be housed in anyone's home, the Fourth Amendment as setting a high legal standard for allowing agents of the state to intrude on someone's home, and the Due Process and Takings Clause of the Fifth Amendment as applying an equally high standard to the government's taking a home or property, reinforced after the Civil War by the 14th Amendment. Alternatively, one could argue that the Ninth Amendment anticipated the existence of a common law right to privacy among other rights, when it acknowledged the existence of basic, natural rights not listed in the Bill of Rights or the body of the Constitution itself. Lawyers Samuel D. Warren and Louis Brandeis, the latter a future Supreme Court justice, famously developed the concept of privacy rights in a law review article published in 1890. Although several state constitutions do list the right to privacy as a protected right, the explicit recognition by the Supreme Court of a right to privacy in the U.S. Constitution emerged only in the middle of the 20th century. In 1965, the court spelled out the right to privacy for the first time in Griswold v. Connecticut, a case that struck down a state law forbidding even married individuals to use any form of contraception. Although many subsequent cases before the Supreme Court also dealt with privacy in the course of intimate sexual conduct, the issue of privacy matters as well in the context of surveillance and monitoring by government and private parties of our activities, movements, and communications. Both these senses of privacy are examined below. Sexual privacy. Although the Griswold case originally pertained only to married couples, in 1972 it was extended to apply the right to obtain contraception to unmarried people as well. Although neither decision was entirely without controversy, The sexual revolution taking place at the time may well have contributed to a sense that anti-contraception laws were at the very least dated, if not in violation of people's rights. The contraceptive coverage controversy surrounding the Hobby Lobby case shows that this topic remains relevant. The Supreme Court's application of the right to privacy doctrine to abortion rights proved far more problematic legally and politically. In 1972, 4 states permitted abortions without restrictions, while 13 allowed abortions if the pregnant woman's life or physical or mental health were endangered, if the fetus would be born with a severe physical or mental defect, or if the pregnancy had resulted from rape or incest. Abortions were completely illegal in Pennsylvania and heavily restricted in the remaining states. On average, several hundred American women a year died as a result of back alley abortions in the 1960s. The legal landscape changed dramatically as a result of the 1973 ruling in Roe v. Wade, in which the Supreme Court decided the right to privacy encompassed a right for women to terminate a pregnancy, at least under certain scenarios. The justices ruled that while the government did have an interest in protecting the potentiality of human life, nonetheless this had to be balanced against the interests of both women's health and women's rights to decide whether to have an abortion. Accordingly, the court established a framework for deciding whether abortions could be regulated based on the fetus's viability, that is, potential to survive outside the womb, and the stage of pregnancy, with no restrictions permissible during the first 3 months of pregnancy, that is, the first trimester, during which abortions were deemed safer for women than childbirth itself. Starting in the 1980s, Supreme Court justices appointed by Republican presidents began to roll back the Roe decision. A key turning point was the court's ruling in Planned Parenthood v. Casey in 1992, in which a plurality of the court rejected Roe's framework based on trimesters of pregnancy and replaced it with the undue burden test, which allows restrictions prior to viability that are not substantial obstacles, undue burdens, to women seeking an abortion. Thus, the court upheld some state restrictions, including a required waiting period between arranging and having an abortion, parental consent, or if not possible for some reason, such as incest, authorization of a judge for minors, and the requirement that women be informed of the health consequences of having an abortion. Other restrictions, such as a requirement that a married woman notify her spouse prior to an abortion, were struck down as an undue burden. Since the Casey decision, many states have passed other restrictions on abortions, such as banning certain procedures, requiring women to have and view an ultrasound before having an abortion, and implementing more stringent licensing and inspection requirements for facilities where abortions are performed. In Whole Woman's Health v. Hellerstedt, 2016, the court reinforced Roe 5-3 by disallowing 2 Texas state regulations regarding the delivery of abortion services. Yet, the abortion issue was far from settled, as the Supreme Court decided in May 2021 to hear in their next term a Mississippi case that would roll back abortion rights considerably. The case would disallow abortions after 15 weeks. The court used the case, Dobbs v. Jackson Women's Health Organization, to strike down in 2022 much of the legal rationale of both Roe v. Wade and Planned Parenthood v. Casey. In the case, the Jackson Women's Health Organization of Mississippi sued Thomas E. Dobbs, a health officer with the state, to challenge Mississippi's state law that banned abortions after 15 weeks of pregnancy, which violated the 24-week timeline established in Planned Parenthood v. Casey and protected by the 14th Amendment's Due Process Clause. The court voted 5-4 to overturn both Roe v. Wade and Planned Parenthood v. Casey, holding that the Constitution does not confer a right to abortion and returning much power on abortion rights to the states. The resultant variation in abortion rights across states continues to settle, as many states had not updated their abortion policies since before Roe. At the end of 2024, 14 states had banned abortion, and an additional 6 states disallowed it between weeks 15 and 24 of the pregnancy. Additionally, arguments about equal access for women to abortion have surfaced, since in many states now, abortion is illegal. Moreover, a salient line has emerged in strict states in terms of what doctors may do to protect the life of the mother, and whether to travel out of state for an abortion. The challenges for doctors and, of course, pregnant women have been most pronounced in Texas, where an especially strict state abortion policy has taken the statewide average of 4,400 abortions per month under Roe down to 5 per month under Dobbs.
Beyond the issues of contraception and abortion, the right to privacy has been interpreted to encompass a more general right for adults to have non-commercial, consensual sexual relationships in private. However, this legal development is relatively new. As recently as 1986, the Supreme Court ruled that states could still criminalize sex acts between two people of the same sex.
That decision was overturned in 2003 in Lawrence v. Texas, which invalidated state laws that criminalized sodomy. Moreover, the 2020 decision in Bostock v. Clayton County established that someone's sexual orientation could not be used as a basis for firing them.
The state and national governments still have leeway to regulate sexual morality to some degree. Anything goes is not the law of the land, even for actions that are consensual. The Supreme Court has declined to strike down laws in a few states that outlaw the sale of vibrators and other sex toys. Prostitution remains illegal in every state, except in certain rural counties in Nevada. Both polygamy, marriage to more than one other person, and bestiality, sex with animals, are illegal everywhere. And, as we saw earlier, the states may regulate obscene materials and, in certain situations, material that may be harmful to minors or otherwise indecent. To this end, states and localities have sought to ban or regulate the production, distribution, and sale of pornography. Privacy of communications and property. Another example of heightened concerns about privacy in the modern era is the reality that society is under pervasive surveillance. In the past, monitoring the public was difficult at best. During the Cold War, regimes in the Soviet bloc employed millions of people as domestic spies and informants in an effort to suppress internal dissent through constant monitoring of the general public. Not only was this effort extremely expensive in terms of the human and monetary capital it required, but it also proved remarkably ineffective. Groups like the East German Stasi and the Romanian Securitate were unable to suppress the popular uprisings that undermined communist one-party rule in most of those countries in the late 1980s. Technology has now made it much easier to track and monitor people. Police cars and roadways are equipped with cameras that can photograph the license plate of every passing car or truck and record it in a database. While allowing police to recover stolen vehicles and catch fleeing suspects, this data can also be used to track the movements of law-abiding citizens. But law enforcement officials don't even have to go to this much work. Millions of car and truck drivers pay tolls electronically without stopping at toll booths, thanks to modern transponders attached to their vehicles, which can be read by scanners well away from any toll road or bridge to monitor traffic flow or any other purpose.
Some locations no longer have a cash option, which means that crossing a bridge or using a road requires the driver to be tracked by the transponder or by their license plate. The pervasive use of GPS, Global Positioning System, raises similar issues.
Even pedestrians and cyclists are relatively easy to track today. Cameras pointed at sidewalks and roadways can employ facial recognition software to identify people as they walk or bike around a city. Many people carry smartphones that constantly report their location to the nearest cell phone tower and broadcast a beacon signal to nearby wireless hotspots and Bluetooth devices. Police can set up a small device called a stingray that identifies and tracks all cell phones that attempt to connect to it within a radius of several thousand feet. With the right software, law enforcement and criminals can remotely activate a phone's microphone and camera, effectively planting a bug in someone's pocket without the person even knowing it. These aren't just gimmicks in a bad science fiction movie. Businesses and governments have openly admitted they are using these methods. Research shows that even metadata, information about the messages we send and the calls we make and receive, such as time, location, sender, and recipient, but excluding their content, can tell governments and businesses a lot about what someone is doing. Even when this information is collected in an anonymous way, it is still possible to trace it back to specific individuals, since people travel and communicate in largely predictable patterns. The next frontier of privacy issues may well be the increased use of drones, small pre-programmed or remotely piloted aircraft. Drones can fly virtually undetected and monitor events from overhead. They can peek into backyards surrounded by fences, and using infrared cameras, they can monitor activity inside houses and other buildings. The Fourth Amendment was written in an era when finding out what was going on in someone's home meant either going inside or peeking through a window. Applying its protections today, when seeing into someone's house can be as easy as looking at a computer screen miles away, is no longer simple. In the United States, many advocates of civil liberties are concerned that laws such as the USA Patriot Act, passed weeks after the 9/11 attacks in 2001, have given the federal government too much power by making it easy for officials to seek and obtain search warrants, or in some cases to bypass warrant requirements altogether. Critics have argued that the Patriot Act has largely been used to prosecute ordinary criminals, in particular drug dealers, rather than terrorists as intended. Most European countries, at least on paper, have opted for laws that protect against such government surveillance, perhaps mindful of past experience with communist and fascist regimes. European countries also tend to have stricter laws limiting the collection, retention, and use of private data by companies, which makes it harder for governments to obtain and use that data. Most recently, the battle between Apple Incorporated and the National Security Agency, NSA, over whether Apple should allow the government access to key information that is encrypted has made the discussion of this trade-off salient once again. A recent court outcome in the United States suggests that America may follow Europe's lead. In Carpenter v. United States, 2018, the first case of its kind, the U.S. Supreme Court ruled that under the Fourth Amendment, police need a search warrant to gather phone location data as evidence to be used in trials. All this is not to say that technological surveillance tools do not have value or are inherently bad. They can be used for many purposes that would benefit society, and perhaps even enhance our freedoms. Spending less time stuck in traffic because we know there's been an accident, detected automatically because the cell phones that normally whiz by at the speed limit are now crawling along, gives us time to spend on more valuable activities. Capturing criminals and terrorists by recognizing them or their vehicles before they can continue their agendas will protect the life, liberty, and property of the public at large. At the same time, however, the emergence of these technologies means calls for vigilance and limits on what businesses and governments can do with the information they collect and the length of time they may retain it. We might also be concerned about how this technology could be used by more oppressive regimes. If the technological resources that are at the disposal of today's governments had been available to the East German Stasi and the Romanian Securitate, would those repressive regimes have fallen? How much privacy and freedom should citizens sacrifice in order to feel safe? This has been American Government 4th Edition, an OpenStax textbook. OpenStax textbooks and this audiobook are covered under a Creative Commons license. The full text is available at www.openstax.org. You can find this audiobook for free anywhere you listen to podcasts, including Spotify, YouTube,
Apple Podcasts, and more. This project was made possible by CC ECHO, the California Consortium for Equitable Change in Hispanic Serving Institutions, Open Educational Resources. You can learn more about CC ECHO by visiting the link in this episode's show notes. Instructors can even download a course shell to embed these recordings in their Canvas courses. Learn more by visiting www.openaudio.us. Did you find this audiobook helpful? If so, let us know by leaving a comment and sharing this recording with a colleague or a friend. Thanks for listening.